Well, this week there was a significant moment in the long-running saga of former Adelaide law firm McGarry Farlam, when a former employee pleaded guilty to 67 counts of fraud and deception. The law firm collapsed when $4.5 million of clients' money went missing between 1998 and 2005. And although the victims who lost their money won't get it back, several are determined to make their voices heard in a national review of the legal profession. Mike Sexton reports.
Is the way the system is. It's the legal profession make the rules. They're self-regulating, so they protect themselves from the public. And, you know, who's got the gold, I should say, makes the golden rule.
John Crane is not a lawyer. He used to be a farmer. But now, after a long and bitter battle with the legal firm, he's determined to change the way the law is practiced in this country. When his father-in-law died 6 years ago, his estate was left in the care of an Adelaide law firm, McGarry Farlam. When John Crane went to claim the money, he was told it had disappeared from the company's trust account. A former McGarry Farlam employee this week pleaded guilty to fraud and deception.
I sort of suspected back in 2004 that there was problems, and in 2005 I was proven correct that there was theft, and from then on it was nothing but disaster all the way through.
John Crane was one of 42 people who collectively lost $4.5 million. In South Australia, there's a guarantee fund designed to compensate people such as John Crane. However, before he could make a claim, he had to spend more than $100,000 exhausting all legal avenues, an unsuccessful pursuit that cost him his farm and his faith in the legal system.
It's a huge cost, actually, because I wasn't going to lay down because I just thought the whole thing was absolutely criminal, the way the victims of a law firm trust account theft were treated in the end like they were the criminal.
Now John Crane is determined to make his voice heard as Australia moves slowly toward a new national regulation of the legal industry that will replace the current systems in each state and territory.
Well, essentially we've got 8 different models of regulation of the legal profession throughout Australia. What we're proposing is to create a truly uniform national legal profession that has benefits obviously in respect to the industry itself.
The legal industry in Australia is estimated to be worth $11 billion per year, and COAG, like the Law Council of Australia, believes national regulation will cut red tape and save millions of dollars.
Currently, it costs something in excess of $65 million to regulate the profession in Australia, and the current estimate is we have nearly 50 to 55 different regulatory bodies that affect the practice of law in Australia, and that, in any context, that can't be good for any business.
At the heart of the proposed changes is the creation of a national 7-person board whose job is to effectively set the rules for the legal industry. Now, originally those board members were to be appointed by the various Attorneys General of the states and territories. But that plan set off alarm bells with the nation's Chief Justices, who argue that if you make the board members political appointees, then you threaten the very independence of the judicial system.
The government shouldn't have that much control over this new entity, which has, I think, unprecedentedly wide powers of control over the profession. I'm not objecting to the width of the powers. I'm just saying if they're all concentrated in one body, all the more reason why we need to be very careful about the degree of control that the attorneys can exercise over that body.
The Law Council of Australia, that represents the interests of lawyers, believes instead that a majority of the board should be appointed by the profession and Chief Justices, simply because they are the experts.
The people that really know how to ensure that regulation works well are the solicitors and barristers and the judiciary of the country.
It strikes me that such a proposal or a proposal along those lines has merit to it. In other words, it would be and truly be seen to be a body that is not controlled by government but nonetheless have the input of the community and specifically including input of consumers.
But John Crane is unimpressed.
When Robert McClellan first came out with the announcement, it was very consumer orientated, but I'm concerned now that the Chief Justices and the states and the legal bodies are eroding Robert McClellan's original potential.
Chris Snow was also a client of McGarry Farlam, but unlike John Crane, his money wasn't touched. Despite this, it still took 3 Supreme Court hearings and 21 months to get his assets back. And along the way, he found the legal industry difficult and uncommunicative, and feared it may continue with the national reforms.
We were unsuccessful at all times in attempting to talk to the Law Society and to the Attorney General. That has carried through to the current national project, where consumers really have been left aside.
It's a complaint the Federal Attorney General McClellan rejects.
We're certainly trying to do the very best we can. Right since the time of the issuing of the public consultation papers last September, we've been receiving feedback from consumer groups and indeed individual consumers.
So today our job is to be here to listen to you.
John Crane was one of a handful of consumers brought to Sydney for a half-day seminar where he pushed for greater protection against malpractice.
And thousands and thousands of emails later, we've actually we've achieved a certain amount, but I can't stop now until I want to see, a national consumer protection scheme for lawyers.
Chris Snow believes the practice of lawyers keeping clients' assets in their own trust funds should stop and be replaced with an independent national account that's independently insured, so people don't go through the heartache he did.
There should be then, with the Fidelity funds, there should be a national insurance scheme that enables all clients' assets to be fully insured for the time that they are in lawyers' trust accounts.
The Attorney-General says a national trust fund isn't on the agenda yet, but he isn't ruling it out.
The current proposal is aimed at getting the structures of the legal profession in order, but downstream that's certainly a project that all those involved recognise is an important one for ongoing work.
The timetable for that ongoing work is affected by the election, and the draft proposals remain open for comment until mid-August.